All right, so we are here at Rosen Injury Law, and I'm here with my good friend Michael Walrath from Walrath Law. Michael Walrath is the renowned expert in the area of medical bills, medical liens. Whenever there is a medical bill or lien issue, his name pops up. So today, you guys are lucky. I'm thrilled to have you. So just tell everyone, what's the name of your law firm and how long you've been in the business of helping other lawyers with medical bills and liens for their personal injury cases?
My law firm's called Walrath Law. I figure it's been about 15 years. And so I finally changed my firm name to a little bit of name recognition play. I have been doing this a long time and helping lawyers, exactly as you said, resolve these medical liens. It's such an important thing. It becomes a case after the case, and it's very time consuming. It's nice to have someone who has specialized in this able to help you.
It's so funny. Like I said, so many times, whether I'm on a listserv or I'm out and I'm talking to someone and they have a medical bill or lien issue, like there's a hospital bill that's hundreds of thousands of dollars. Every time that comes up, your name comes up.
Well, that's good. I'm happy to hear that. I think it's the ultimate one-trick pony. I've been doing this one thing so long that people know that I usually have the answers and right off the top of my head if they just give me a call.
And what's cool about it is because our niche is personal injury and of all different types of cases, car accidents, motorcycle accidents. And I just love that you niched down and you said, this is where I'm going to become the renowned premier expert is medical bills. Right? I mean, has that been what you've dedicated your career to learning, understanding, and helping other lawyers get those bills wiped out or reduced or dramatically reduced?
That's correct. It's the one issue is really what is the reasonable value of healthcare? And that issue has been the only thing I've done my entire legal career. I've done it from a few different perspectives. I worked in managed care for a while, litigating and negotiating both managed care contracts and out-of-network care, but it's all the same thing. What is the reasonable value? And for you guys, for plaintiffs lawyers who have these liens that are frankly quite one-sided in favor of the hospital, the law is in favor of them, at least the ordinances that create the liens are in favor of the hospitals. Luckily, we've developed some case law in Florida that's favorable to us. And so you need someone who can utilize that case law to level the playing field for you.
And I'm sure other personal injury lawyers out there, because if you're a personal injury lawyer, you need to be watching this episode and our discussion. But I see it all the time where hospital bills are outrageous, right? Just in an astronomical number, or even orthopedic doctors, chiropractors. So how do you, where's the first line of attack if you're looking at these bills and you're trying to get them reduced?
Well, with the touchstone being the reasonable value, that's your goal, is getting it to the reasonable value. From an analysis standpoint, the simple answer is I first look at the bills to remove things that I think are non-billable, things that shouldn't be there at all. Unbundling, things like that, where they charge you for something and then somehow charge you for it again under a different structure. Once we remove all of those things, we reprice those bills to the reasonable value of all the billable care. And the way we do that is hospitals in particular submit data to the federal government every year under oath that lets you dial in all the way down to their cost of care. I can tell you by analyzing a hospital bill how much it costs the hospital to treat your patient. Then it's just a negotiation of the profit above that cost.
And it's so funny because it happens. Lawyers, personal injury lawyers, and I'm someone that's hyper aware of this. My team's hyper aware, and we just had a case I'm going to talk about in a little bit about how you helped me out on a massive bill, get it dramatically reduced to an astronomically low number. But so many personal injury lawyers don't realize that, or at least don't follow up to get these bills reduced, right?
Yeah. Well, the hospitals expect that. The hospitals know that this is the case after the case for you, and they know that they have the money hostage. You have to hold it in trust according to the bar. So you got clients calling, you've got other cases to get to, and the hospital knows they can just stonewall you if you don't have someone who's willing to take them to task or even take them to court.
So if someone's a personal injury lawyer and, let's just say they get their case resolved, there's a hospital bill that's $50,000 or $70,000 or $100,000 or whatever the number is. Maybe the hospital filed a lien, maybe they didn't. Is that something that you help them out with to get that dramatically reduced so that their client gets more money in their pocket?
Absolutely. That's exactly what we do. And we do it through the analysis that I just described. And it ends up being on average about a 65 to 70% discount off of the billed charges. And that's when you have the money. Obviously, you've had many cases, I'm sure everybody has, where you don't have enough money to pay all the bills, and those get reduced on percentages or pro rata bases. But even if you've got the millions and millions of dollars in settlement proceeds and a big bill, there's no reason to pay that bill, even though the hospital pretends that that's really what you owe.
Yeah, and the best part, and from what I understand, and just maybe correct me if I'm wrong, but how is it that you charge for your time? Do you get a percentage of the reduction that you're able to obtain for the client? So essentially, that client wasn't going to have that money to begin with. You get it reduced and you get paid from the portion of the reduction?
Exactly right. Yeah. So I like to say that we're never a cost, right? It's never an additional expense to your client to use us. In fact, for every dollar that we make, the client makes an additional $2 in their settlement. My fees are a third of the savings that I obtain. I also give a 50% reduction if I resolve it pre-suit. So it goes down to 16.67% of savings if it's resolved before litigation.
Wow, that's great. And so, it's also, because it happens all the time, right? A big lien from a hospital. So, sometimes, and I know that you know this, but sometimes it's not what you know about the bills, but also who you know at the hospitals. Do you have contacts at a number of the major hospitals in Florida so that if you see a bill, you're able to reach out, you know the person?
Absolutely, I do. And in addition to that, even the folks I don't know, unfortunately for them, know me because I have sued every hospital in this state numerous times and every system in this state numerous times, including in class action scenarios. So typically they know, unlike some of the more mill-type lien resolution companies who can't really do anything after the negotiation phase, they know that my negotiation phase is short and they know what comes next.
Yeah, and that's great. What's different about Walrath law is that, when it comes to the lien resolution, as opposed to these institutionalized lien companies, they don't have the lawyers, or maybe they don't have the lawyers, they don't have the contacts. You're the lawyer, you represent the patient, you can go directly after that hospital if you need to.
Correct. I have a lot of my personal injury referral sources that don't want me to negotiate at all. They want me to go straight to litigation because they feel like that's the quicker, faster, and deeper reductions available that way. So yeah, I don't have to, I'm not at the whim of the hospital when they feel like responding to me.
And you said something also, it's not just who you know, but it's that they know you.
Correct. I've literally litigated every hospital system numerous times over the last almost 15 years.
And it's, other lawyers, personal injury lawyers, really need to understand that and digest that, because if the hospital knows who you are and that you're willing to file suit and take them to the full length to get that bill reduced, they're going to respect you. They're going to come to the table and you're going to get better value. That's my opinion. What do you think?
I think that's true. And I think, although it's sort of antithetical to my business, after a hospital becomes trained, so to speak, to know that a certain injury firm is using me, sometimes they can get things resolved without me, which I'm always here for the clients and for you guys. If you can get a bill resolved without me, I'm happy for you. And I think I lead to that after I've sued on your clients' behalf a few times.
And it's so funny because I had a case recently where we had a $1.9 million lien.
Yep.
And what was crazy about it was that we got the case settled based on the representation from the hospital. There was a massive charitable write-off. Mm-hmm. They had reduced the 1.8 to like $160,000. And then when they found out lawyers were involved, they put it right back to the 1.8 million. Does that happen in from your experience? My experience is that happens every time. Every time that they learn of a third-party recovery, they reverse those charitable discounts. It's literally the policies that I've read, the charity care policies at the few hospitals where I've gotten that in litigation, they literally say they have to. They have to reverse those when there's a third-party recovery. So I want to break this down just for a second, because really personal injury lawyers really need to listen to this and understand and strategize. Because I think it's unscrupulous behavior on behalf of the hospitals, right? Do you suggest a lawyer, if they're a personal injury lawyer and they have a case and they see that the hospital has taken that charitable write-off, to contact you before they reach out to them to pay? Yes. I think at least strategize. I do think it's always worth reaching out to me, because there's no obligation, there's no cost in doing so, and I'm happy to talk about these things. Yeah. So I always recommend people do that if they have any questions at all. I will say, though, that on this issue,
the hospital's going to reverse that. There's nothing I can do to change it. I know that you had a fantastic result in that case that you were just describing, and I think that's great. It's very unusual that they agree, but there are circumstances sometimes where they've pinned themselves in, depending on how you asked for it, when you asked for it, what was said. But those discounts typically get reversed.
But you see the legal strategy behind when that type of behavior from hospitals occurs, whether it's legal or illegal, okay? And let's just assume it's legal, but there's something not right about it, right? And the question comes down to contracts. But when I reached out and we discussed this, the issue came down to there was a big lien. They wrote it was a charitable write-off. Then they found out that there were lawyers involved, so they just reversed it, okay? But we had settled the case based upon the representation from the hospital, what the lower number was, which means our client was going to get screwed and we were lied to. That's how I looked at it. And really the idea, in your experience, do you see that type of a response to the hospital saying, hey, listen, we're dealing with promissory estoppel. We're dealing with a representation that we relied upon to our detriment.
Reliance, absolutely. Yes, those are exactly the right sort of buzzwords to be using, but it really depends on the facts of your interaction, right? If it's just a bill, the thing to remember is that the bills that you get, quite often, the billing system puts those discounts on there. It's not a decision made by the hospital. It's a systemic thing. And many of the people who work for the hospitals in the collection of these debts and liens specifically tell you up front, all charitable write-offs on bills are void. Really? They don't, like hospital lien strategies, if you've ever dealt with them with some of your Dade hospitals mostly, but I think they do a few in Broward as well. They have it right on every one of their letters at the bottom, like a debt collector has. They have a statement that says charity care discounts are reversed upon discovery of a third-party recovery. Yeah,
so this is something I think that if anyone has a big hospital lien, the case hasn't settled yet, they've received a letter from the hospital saying that there's been a charitable write-off, that's a moment in time where you just have to strategize a little bit.
Yeah, don't go down the wrong path and assume you can rely on it. You want to make sure what your plan is, and you want to make sure to document. If the hospital really is standing behind that, get it documented, because that's huge.
There are too many lawyers that have big egos and they say, I can do this all myself, right? Then there's smart lawyers. I'm going to put myself in the smart lawyer category where I know where I'm really good at, and then I know, okay, now I need to consult with someone who has more expertise in the area, right? So is that, like I said, when lawyers have these hospital bills or liens, or maybe they're dealing with a chiropractor that's being extremely difficult, is that a moment in time where they should call Walrath Law? Yeah.
I've seen, I don't think there's any scenario I haven't seen. So I've seen them all. I've seen when they go well, and I've seen when they don't. And usually when they don't is exactly the kind of thing you're talking about, when people assumed everything was going to work out, and especially when they make representations to their clients about, oh, don't worry, I'll be able to get this reduced, I'll be able to get this down to X, because you are at the whim of the providers if you're not willing to go to suit over it. And going to suit over it takes a lot of time, and it's all a sunk cost on your injury case, really.
Yeah. So do you, what about letters of protection, or someone's settling, let's just say a personal injury lawyer settles their case, and either there is or there isn't a letter of protection. Are they responsible? Is the lawyer responsible for keeping that money in trust until it's resolved? Explain that.
Yes, there's been a lot of flux on this point over the past few years. A few years ago, the bar took the position that if there was any accident-related care, you have to protect that in trust. So if you know of a bill, a medical provider of any kind that treated your client, and you know it was related to the accident, and you recovered money, you had to hold that money in trust to get that bill resolved. They were giving this advice out on the hotline, and a lot of lawyers, of course, took their advice and assumed that was the state of the ethics on this. They have since clarified and reversed course, frankly, and now it's pretty clear. They've issued several staff opinions, at least 3 that I'm aware of, that say if there's a third party with a legal interest in those settlement proceeds, then under the trust rules, you have to hold that money in trust. But if there is not, and that is really just the bar's way of saying a lien. They don't like the word lien because it isn't defined, so they call it a legal interest in the settlement proceeds. But in the settlement proceeds is the important part. It isn't just a legal interest against your client. That's just a debt. A lien attaches to the settlement, a debt attaches to the person. Now, if there is a lien, you have to hold it because of the trust rules. If there's not a lien, if it's a mere debt, just a medical provider, a good example is ambulances. Ambulances don't have liens. They don't have your client sign a lien, and they don't have a statutory lien. Those bills, while we all like to see them paid, and they're doing God's work, of course, they're the one who scooped your client up, really important stuff. But If the client chooses not to pay that bill out of their settlement and tell you to give them the money instead, they can do that. And you can do that. Yes, and you cannot deny your client's demand for that money if there's not a lien against that settlement.
Yeah, I think a lot of lawyers, are concerned that it may have repercussions to them, either ethically or they may have to pay out of their own pocket to the provider. But still in that scenario, the idea is that, listen, you are giving the client the money and they are going to be responsible for paying whatever bill it is, and they're going to have to negotiate it.
Correct.
We typically, I almost universally, universally, we get the bill. We want the bills paid from the settlement. And it's really the goal.
Most of the times, that's everyone's goal. Yeah. But we all have experienced those clients who really don't care about medical debt. Yeah. They want to maximize their in-pocket proceeds from this, usually a small recovery. And they say, I only want to pay what I have to pay. And the rest of it, they're never going to be able to collect it from me because I don't have anything. And this money will be gone by then.
Tell, I guess, the personal injury lawyers that are watching this, like what kind of experience you have with reviewing those itemized bills and then making sure that it is the reasonable value of services.
Sure. We do a comprehensive analysis of every bill that we handle, unless it's a purely equitable case, unless it's a case where you've got $500,000 in medicals and a $50,000 recovery. There isn't any real value in analyzing those bills at that time because you can't afford to pay the reasonable value any more than you can the full bill charges. Assuming that there is enough money in trust to pay these bills, we want to get them reduced to the reasonable value through the process that I described before, removing non-billables and then repricing the billable care to the reasonable value, using whatever data is available depending on the kind of provider.
And then obviously if it can't be resolved amicably, you have the experience to file that equitable distribution, bring it to court, and argue to the judge, here are the reasons why X, Y, and Z should be distributed this way so that the client gets money.
Equitable distributions can be litigated.
Yeah.
They are something that I have learned over the years is better to be litigated by the personal injury lawyer than by a third party.
Yeah.
Because when I go in there and say there's no money to go around, the judge automatically looks at me and wonders, well, what are you doing here?
Yeah.
So, but what I do is I help the lawyers through that. I do have templates for all that stuff. And if I can't get it resolved, but normally I can get those resolved because hospitals and doctors that work in this space know that if they don't get these resolved with you, you're going to stop taking those cases and stop acting as their sort of free collection agent on this stuff.
Yeah. So just tell everybody, for the personal injury lawyers, medical malpractice lawyers that are watching right now that handle these kind of cases, when is it that a hospital lien attaches? Like, do they automatically have a lien?
Well, it's a great question. There's a lot of discussion about this because normally you look at the ordinance, and the ordinances do have timeframes that say the hospital has to file their suit within a certain period, file their lien within a certain period of time. However, the case law says that doesn't really change anything about the validity of the lien. So even if a hospital files late, even if a hospital hasn't filed yet, they do, under the case law, have an automatic lien that attached on the date of service. So they have a lien, and you need to be aware of that. Their late filing merely affects the priority. So they could get behind someone else, like the lawyer, for example. Now your fee agreement may predate the hospital filing their lien, which means that they've lost their first priority to you.
What can happen from, just what you know, if a lawyer knows about a lien and then they disperse the money anyways? I mean, what can happen to that lawyer?
There's a lot of exposure. Yeah. There's even instances of lawyers being disbarred for ignoring liens. Yeah. And on the statutory lien side, hospital liens in particular, there are impairment provisions in those ordinances. The lawyer or the law firm can be responsible for the bill itself plus fees and costs for impairment.
Yeah, so lawyers just need to be aware of when the lien attaches, even if they haven't filed a lien, but then they file a lien later on. This is something that the lawyers, if they have any question about, should call you.
And I recommend when you're trying to determine if a provider has a lien, because that's obviously the most important question here, you have to ask them. You can't rely on whether they filed, when they filed, if they've given you a copy of a letter of protection. If you have medical providers who treated your client, I recommend you reach out to them before you disperse and you ask them, are you asserting a lien? And if you are, please provide me documentation.
And if they don't have documentation, what happens then?
If they don't have documentation, now you have probably the last remaining gray area with regards to the bar's ethical requirements. So if they don't have documentation, it stands to reason to me that they don't have a lien. If they had documentation, there's zero reason for them not to give it to you. However, you can't just assume that, and it seems as though you do need to have it adjudicated. So you would go to court and you would convince the judge through your efforts to try to get this documentation to say you've waived any lien rights you have because they've not provided you any documentation. And if they don't have it, the judge is going to rule they don't have it.
All right. So just so we can qualify you, okay, in Florida, right? Who created the seminal case, okay, out of the second DCA when it comes to dealing with reasonable value services, hospital liens? Who is it?
The Giacalone case is the one you're referring to, was my case in the second DCA in, I believe, 2009. That solidified my path, so to speak. When I got that opinion, I had been litigating against hospitals to determine the reasonable value of their care for a couple of years at that time. That case came out and gave me broad discovery of a hospital's managed care rates and all this other stuff they don't want. And from then on, I've been able to resolve hospital liens relatively easy. That case has been cited over and over again as sort of the seminal case on reasonable value of hospital care.
I'm telling you, so many people don't realize the complexity behind the reduction in litigation of these liens. You know, knowing even to look into the hospital's managed care, what they're paying, how much they actually have to pay, what their profit is, it gets very complex, which is why people need to bring in an expert for these kind of things. Right?
Well, I appreciate it. And yes, that's true. It's a whole nother area.
So just tell everybody, how can someone get in touch with you to reach out and if they have questions about a lien, other lawyers, if they have any issues regarding medical bills, medical liens, hospital bills, chiropractor bills, orthopedic bills, how can they reach out and get in touch with you?
I'm easy to reach. I can usually be found on any one of the state listservs, for one thing. Anybody post a lien question on there, they usually get a response from me pretty quickly. I can also, of course, be reached directly. My email is michael@Walrath Law, and my phone number is 786-332-6855. I'm happy to talk to anybody anytime. There's no obligation or fees or anything to give me a shout.
What's the website?
Walrathlaw.com.
There you go. As easy as it comes, right? That's that is the branding, walrathlaw.com, to find out for personal injury lawyers in Florida and other types of lawyers who are dealing with hospital bills, hospital liens. That's how they get in touch, man. I'm super thrilled that you came.
I appreciate you.
The man, the myth, and the legend in Rosen Injury Law's office. I love it. All right. So
thanks so much.